we only expect basically negative things to come out of that. I mean, it would be one thing if he hadn't been charged with if there was some kind of accusation of a cover-up or things of that nature, where you really need to see it to see what your government is up to. But frankly, he's been charged. This is a temporary request just to protect the case and to protect the integrity of the system and the integrity of the individual who was killed, as well as his family members. And so we would again assert that those rights should prevail over the rights of the media to have access to this video. Thank you.
Thank you. Mr. Richards, on behalf of Ms. Sweet, did you want to be heard?
Yes, Your Honor. Your Honor, I apologize. My mic on now?
It is.
Okay. Thank you, Judge. There are a number of issues I think need to be considered here. I'll try and get to them as briefly as I can. Number one, the fair trial issue. Counsel indicated, we all know you read the decisions. The U.S. Supreme Court and the Arizona Supreme Court have said repeatedly, time and time again now, that there is no fair trial or impartiality, jury impartiality issue that is created by release of factual information about a crime. It just doesn't happen. And therefore, the law is singular in this case in terms of favoring release. Number two, Your Honor, the video has not been kept sealed. We heard testimony just yesterday from Sergeant Langley that after he retired from the police department, he was given a copy of that video to review. I'm assuming it's by counsel. We don't know for certain, but he was not even a member of the police department at the time. In addition, Your Honor, I could be wrong on this, but what I was hearing yesterday from the offer of proof was that I believe that the expert, who was never a member of the Mesa Police Department, has been given a copy of the video to review. In addition, Your Honor, we have had commentary now for several days on the video itself. We have had Detective Sipe saw the video and has commented on it publicly, on its contents, at length and in detail. We've had Sergeant Langley saw the video, comment on it at length and in detail. We've had the state, who's seen the video, comment on it at length and in detail. We've had defense counsel do the same thing. Your Honor, the only person who has a constitutional and statutory right to be a participant in this process, the only persons, I should say, who have not had a chance to see the video and comment on it publicly in any way are the victims. Everybody else has now had a chance. In addition, Your Honor, there's a procedural issue here. This is a verbal motion, apparently, for reconsideration, which we don't believe is appropriate under the rules. And I would like to point out that your ruling has been in effect now for well over a week. If counsel wanted reconsideration, counsel could have appropriately followed the rules and filed a written motion seeking your reconsideration upon new grounds, new considerations, to overturn that ruling. Counsel could have filed a special action with the Court of Appeals. And frankly, had they done that, we probably would have joined with our own cross-motion or cross-appeal somehow. They didn't do any of that. In fact, I asked Mr. Marins yesterday after we concluded if he was going to continue to object to the release of the video, and he wouldn't tell me. He refused to tell me. So, frankly, Your Honor, as far as we're concerned, this is a sandbagging attempt to keep the public and the victims in particular from seeing the basic factual information. Let me make one last point, Your Honor, if I can. The public interest in all of this. You are absolutely correct in ruling that this is a public record and ruling that there are significant public interests in seeing a video of public police officers in action. That, in fact, the public in this country and in this state has an extremely important right to know what their public officers are doing and how they're treating the public. And that is a matter of in this day and age, one of the greatest matters of public debate and concern and discussion in this country, as well it should be. Your Honor, the best interests of the state here, the best interests of the state are that the victims who have a right to see the video and to participate meaningfully in the prosecution of the case get to see the video. The best interests of the state, Your Honor, also include the public knowing what their public officers have done. And, Your Honor, counsel for the state, with all due respect, raised an argument here that I hadn't thought about a whole lot before, but she said there's no evidence here of any sort of a cover-up. With all due respect, Your Honor, I heard lots of evidence yesterday of a cover-up. I heard testimony that these officers, immediately after shooting Daniel Shaver, before they finished securing the area, they turned their cameras off. Well, why in the world would you do that? I heard testimony that the officers were segregated away and that they met with potentially counsel or other representatives, and that the defendant was not available for 3.5 hours for an interview. I heard testimony that when the reports were done by the officers at the scene, somehow they all end up omitting the same important critical facts about Daniel Shaver crying, about Daniel Shaver asking not to be shot, about Daniel Shaver's cooperation and perceptions of cooperation, and they all end up including the exact same descriptions of the threat. Now, Your Honor, I think the public's entitled to know, is the information that was put out there by the police in their reports that have already been released to the public, are they accurate? Are they truthful? Are they complete? Or are they instead something else? And that gets to the core functions within our society, Your Honor, of public accountability. Now, I would re-urge also to you that the victims have rights. And you've acknowledged that you don't believe that the state has an obligation to provide this evidence. I think the perspective is a little bit different, though, at this point in time. It's not a question of whether they have an obligation to provide it under the victims' rights statutes and Constitution. We believe they do. But it's whether or not the victims, both because of their role as victims, their special place as victims, and their special place as basic citizens with public interest in this community, have a right to see what happened when their loved one was killed. And with that, Your Honor, I would respectfully urge that you uphold your ruling and direct that those videos be released immediately to the victims. Thank you.
Thank you, Mr. Richard. Mr. Budge, on behalf of the Shaver family, did you want to be heard?
Yes, Your Honor. On behalf of my clients, it's twofold. One, this is their son that was killed. This is not something that they want publicized for dignity reasons, for privacy reasons. They understand eventually it will come out, but want that to be after the trial. The issue here stems from the effect that this could have on potential jurors, on the integrity of the court system. Looking to limit all the risks in this. I know the defense counsel's probably got some motions probably already drafted to look for mistrial or change of venue or things like that. The intent is to minimize those risks and to help the prosecution in this case going forward. There's nothing to be gained by it. There's so many reasons to keep it protected. The victims have had an opportunity to see it, albeit with qualifications, but didn't take that opportunity. The concern also that I have is not necessarily the viewing of the video, but the publicity of the video. Jurors seeing the video on the news isn't necessarily going to sway their opinion, but what is going to influence them is the unqualified judgments that will be made about that video. And that's a concern that I have as well, that could influence potential jurors. Your Honor, with that, I'll say that those are the two big reasons. The publicity that I would like to impress upon your minds, the effect that this has had upon my clients. This is their son. It wasn't any of our children in this case. It was their son that was shot and killed, and they don't want that to be publicized for individuals to see on the internet to get their kicks from, and they also want to protect the integrity of the system and not influence any potential jurors that would open the door to the risk of any motions being filed later on. Thank you.
Thank you, Mr. Budge. Mr. Bodney, did you want to be heard on behalf of the media parties?
Yes, thank you, Your Honor. On behalf of Phoenix Newspapers, KPNX, Scripps Media, Channel 15, Meredith, Channels 3 and 5, and the Associated Press, we appreciate this opportunity to be heard, and we would urge you to deny the motion for reconsideration. Briefly, I would just like to address some of the points that I've heard this morning. First, from the defendant was the notion that the release of the video would make it more difficult to pick a jury. I believe I heard defendant's counsel say, quote, maybe it's possible, close quote. I would just remind the court that it was 40 years ago in Nebraska Press Association versus Stewart, decided by the U.S. Supreme Court, when that court said, and I quote, pretrial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial, close quote. And more recently, the Supreme Court of the United States in the Min versus Virginia case found that it is easy enough, even in a county with a population of approximately 183,000, to find an unbiased panel. I would submit that this is hardly the first time that a court has grappled with the issue of potentially prejudicial pretrial publicity, and that key evidence, factual evidence about allegedly criminal activity belongs in the public record. There is just no question that these videos are public records, that there is a strong policy in favor of public access to them, as decided by the Arizona Supreme Court repeatedly, and that these videos are the functional equivalent of police departmental records. And our Supreme Court in Arizona held in Cox versus Collins that there is no exception for law enforcement records, and there is no exception in law today for these videos. Videos of shootings by police have been made public, and I think folks in Chicago might be in the best position to discuss with some real experience the fallout of waiting too long to make public records public and causing unnecessary speculation either about the conduct of a police officer or the conduct of a suspect, or perhaps in this case a victim. So is there nothing to be gained by it, as I heard one of the lawyers say? I think there is the world to be gained by bringing some certainty to this issue and respect for the judicial and law enforcement processes. I guess it was defense counsel who urged the court to err on the side of caution, and respecting Your Honor's time and the time of all those in court this morning, let me just conclude with this thought. I think the court has erred on the side of caution, particularly so, and paid due respect to the concerns of the state and the defendant and some of the victims, but not others. It's now been 120 days, 4 months, or thereabouts, since these public records were created. The state and the defendant have effectively bottled up public access to a public record. And as I mentioned when this issue first arose in court, there is ample appellate authority in Arizona for the proposition that delays of this length of time, if not less than this length of time, does not constitute, quote, prompt, close quote, compliance with the public records law. But that's what the public records law requires, that public records be made available for inspection and copying promptly. And to the extent Your Honor has seen the videos and believes that some fragment of them should be redacted to protect certain genuinely graphic and sensitive matters, my clients, the media interveners, do not object. We understand that issue. But there is so much here that could help answer questions for the public. We believe these records should be made available without further delay. And I thank you.
Thank you, Mr. Bodney. Mr. Marins, this was your motion. If you want the last word, I'll give it to you.
Thank you, Judge. Just to respond to one point Mr. Bodney made, as to like Chicago, this is a much different situation. The issue in Chicago was trying to find out what to do with certain people, and we are here because the state is doing something, and we need to protect what the state is doing so Mr. Brailsford can have a fair trial. Thank you.
Thank you. The court has considered the motion for reconsideration, the defendant's oral motion for reconsideration, and the positions of the parties. Because there is a change in circumstance, and that is the court's finding of probable cause on the charge against the defendant, the court finds that the motion is well taken and reconsideration is appropriate based on that change in circumstance. And while Mr. Richards makes a good point that the motion appears to be made suddenly and orally rather than in writing, because of the court's previous order that the materials would be made public upon completion of the preliminary hearing, the court will allow the oral motion to proceed, although clearly the rules contemplate that it be done in writing. As the court had indicated at the previous hearing, this is a public record and it will be made public. It will be released. There is no question that it will be released. The issue is really when. Mr. Bodney stated key evidence belongs in the public record. I absolutely agree with that. But the question is, when should it become public, and when balanced against a defendant's right to a fair trial and an impartial jury, that question sometimes becomes more difficult. The court is in a different position now, having reviewed the video as part of the evidence at the preliminary hearing, and having done so, I agree with counsel that there are portions of the video that should remain sealed until the trial is completed. As Mr. Bodney indicated, even the media parties can appreciate that some redactions may be appropriate. So having said all of that, I am going to grant the motion for reconsideration in part, and I will keep portions of the video under seal. I am inclined to allow portions of the video to be released. Ms. Charbel, let me ask you, technology-wise, if the court orders that certain minutes and seconds of the video are to be made public, does the county have the ability to comply with that?
Yes, we do. Thank you.
Okay. All right. So I will enter a written order in regard to which portions of the video will remain sealed and which portions can be made public.
Your Honor, I apologize. I would like a clarification on one thing. The victims I represent still need to see the entire video. Now, other parties have now been allowed access to it. In fact, non-parties have been allowed access to it, as you've seen in the testimony. I think it's only fair and appropriate. We can deal with the other issues separately if we need to, but that your order at least include that the full video be released, not to be released further at this time, but the full video be released for the victims and counsel to review.
And Mr. Richards, I believe you raised that motion at the previous hearing. You asked the court to order the state to release a copy to the victim. As I indicated at that time, and my position hasn't changed, I don't think the court has any authority to enter that order, but your request is on the record, and I'll deny that request.
Your Honor, I'm sorry, I didn't mean to interrupt you.
Go ahead.
I would move to seal Exhibit 10, which is the audio of the video.
What is the state's position?
Did you mention, if I could just 1 second.
Exhibit 10 is a transcript of the audio of the video.
Yes, sir. Sorry, I misspoke.
Judge, I'm not so sure it's a good idea to seal it at this point, only because it's all in the record. I mean, we read almost verbatim from it, including a defense counsel himself reading into the record, so I don't know how much good it would do to seal it. I mean, I suppose we can seal the exhibit itself, but anyone who requests the transcript of this hearing will have heard everything that's on there.
We didn't read, we just read parts of it. I don't know what parts of the video the court's going to seal, so until the court has, why don't we seal it at least until we see what the part of the video the court is sealing?
I will take that request under consideration. I'll review Exhibit 10 and make a determination whether I believe sealing is appropriate.
Thank you.
Your Honor, if I could make my record on that one, since obviously that wasn't part of the other issue before that we had a chance to address.
I think this is more of a trial issue, and I'm not sure that the victim gets a voice on what the court does with a piece of with an exhibit that is in evidence.
Yeah, I'm not suggesting that, Your Honor. I'm suggesting, though, that it sounds like you're being asked to do is, again, issue an order that would prevent the state or anybody from showing the victims a piece of evidence that has now been admitted already, without any restrictions, has been testified to in detail. And again, I simply want to make a record that, irrespective of the trial control issue, we believe that an order that would go that far would be inappropriate in violation of our client's rights.
Thank you. Mr. Marins, before we took our break, it was my understanding and it was my intention to do a not guilty arraignment for Mr. Brailsford, and that's what I thought I was doing so that he would not have to come back for a 2-minute proceeding before his complex case scheduling conference. Did you have any objection to that proceeding?
It wasn't so much an objection, it's just that until they file the information, he can't do it, I don't think. But
It's right there.
Ms. Charbel said she was going to get one here, and if she has it here, we can do it now. And I certainly have no objection to that.
And I've already said everything to him that I would say in an arraignment. Entered a not guilty plea. I advised him of his right to counsel, his right to remain silent, advised him of his next court date, affirmed release conditions.
If he doesn't have to come back, no problem.
Okay.
Okay.
All right. Mr. Marins, did you want to see the information that is being filed?
I'd like to have a copy, that's all.
Mayor Pro Tem.
You may. We'll do the copy as soon as we're done. All right, so the court notes that an information has now been filed, and the court will have the record reflect that a not guilty arraignment has occurred, and will affirm the court date that I previously indicated before Judge Foster. As the court has affirmed release conditions, Mr. Marins, there's some paperwork for your client to sign as soon as we're done. Anything else for this morning on behalf of the state? Anything else on behalf of the defendant?
No, Your Honor.
We are adjourned. Thank you.